Another Hong Kong related question, but again it applies to all jurisdictions, is that if there is no double tax treaty between, in this particular instance, Hong Kong and the United States, but there are exchange of information agreements. So there are various types of exchange of information agreements, FATCA, the Model 2 IGA, where these jurisdictions are entitled to exchange information with each other. What does this mean from an international tax perspective in the interaction between the example of Hong Kong and the United States? Well, of course, Hong Kong and the United States, in terms of those agreements, are entitled to exchange information with each other pertaining to the tax affairs of their respective taxpayers. Now, that being the case, one would still have to look at the specific domestic information provision clauses in the Hong Kong legislation or in the United States legislation to make sure that the respective revenue authorities are fully compliant with that which they are exchanging with each other. It doesn't take the relationship any further. Should any tax liability arise between those two jurisdictions, there will be no double tax relief as such, which would typically be provided in a double tax treaty between the two countries. Although in both those jurisdictions, as is the case with most, if you have been exposed to taxation in one of the jurisdictions and let's say in the other jurisdictions in the United States, and you're now exposed to taxation in Hong Kong as well, typically the Hong Kong Revenue Authority and that legislation will grant you some sort of credit of the taxes paid in the United States. Those provisions are fairly onerous typically to meet, and unless you are able to tick all the boxes, just as much as the Revenue Authority can only act in terms of its scope of powers based on exactly what it is entitled to do in terms of those powers, you can only claim those credits to the extent that you have complied with all the tick boxes, all the requirements for the purposes of claiming that credit. And sometimes there's a lot of difficulty in obtaining the necessary documentation to do so. So there are numerous stumbling blocks, and it certainly often works on the basis that you're not going to find yourself in a position where, by virtue of these credits, you can escape taxation completely. The sections are typically written in such a way that the absolute minimum credit is going to be the one that you would be entitled to claim. Now, if you are a multinational, and let us say that you are transacting with the United States and you also have subsidiaries in other jurisdictions. So we started off with Hong Kong and the United States, no double tax treaty. But let's say you, for instance, have a subsidiary in South Africa, which has a double tax treaty with the United States. And the US is now tackling a particular transfer pricing adjustment between the United States and Hong Kong. And that particular transfer pricing adjustment is covered by the provisions of the double tax treaty between South Africa and the United States. There is a case to be made out that in terms of the general agreement on trade and tariffs and the general agreement on services, which is a field typically only applied in the customs and excise environment, that in that particular instance there are certain non-discriminatory clauses that may be relied upon to ensure that the United States does not treat Hong Kong in a more discriminatory fashion. Now, this is quite a sophisticated area of international tax law, and we do touch upon this in the course of this course, more so for the purposes of bringing your attention to the possibility of taking advantage of these anti-discriminatory clauses, but they are particularly tricky to invoke. Although and I'll give you a classic example, which is maybe not specifically in point with the example that I'm discussing with you now, but here's a classic example. The Americans were exporting electronic goods to China. And in terms of the Chinese value-added tax legislation, input tax credits were not being granted to the United States exporters, which were in fact being granted to the suppliers of those similar electronic goods within China. And so there was this discriminatory provision between the value-added tax of the People's Republic of China, which allowed input tax credits for the local Chinese corporations, but not in this case the American corporations or any other corporation for that matter. And so the Americans enlisted a dispute against the Chinese in respect of that discriminatory provision in their Value-Added Tax Act. And believe it or not, the Chinese were then compelled to change their VAT laws to eliminate that particular discriminatory provision that existed. So there are a number of limited examples like that, but this is an area of international tax law, in my view, that requires much development, and that will only come with more corporations being prepared to investigate the opportunities to challenge authorities where these discriminatory provisions exist. And I come back to my example where I said to you, if there is an existing body of tax treaties within the same multinational enterprise, and in my case, Hong Kong and the US, no DTA, but there's a DTA between the US and the South African subsidiary, there is scope to develop arguments that the most favored nation clause is what they refer to, as would exist in the double tax treaty between South Africa and the US, should equally be applied in the transactions with Hong Kong in this case, so as to eliminate any form of discrimination. So that, fairly long answer to, the fact that there is no DTA and what would that relationship look like, and that's a classic example of what one could look at achieving in the event that there is a negative revised assessment raised.